Hi, my name is Chris Eukins. I'm a professor at George Washington University Law School in Washington, D.C. And thank you for joining this part of Anti-Corruption Measures in Procurement, Public and Private Perspectives. This unit is Unit 2B, where we talk about compliance issues. This is a course sponsored by the International Anti-Corruption Academy. Again, thank you for joining us. In this unit, we'll be offering a first introduction to issues of compliance. We will be focusing on compliance issues primarily as they relate to contractors, to corporations, to vendors. There are some systems such as the Dominican Republic which are beginning to consider imposing compliance requirements on agencies as well, on public agencies. But really the focus since the 1990s has been on corporate compliance systems around the world, and that will be our focus here in this unit. We'll be talking first about the different pathways to compliance requirements. Different countries, different systems have evolved into develop compliance requirements. While the compliance requirements are basically the same from country to country, how we get there, how we get to requiring a compliance system, whether or not it's by statute or by contract or otherwise, that does differ from country to country. But as we'll be seeing, the compliance systems themselves, the systems that the corporations set up, those compliance systems look really remarkably identical from country to country. So we'll be going through these common elements. What are the common elements that we see around the world for a compliance system? We'll be going through them element by element, and then we'll be finishing up with some cutting edge issues in terms of new types of elements that may be required in compliance systems, again, compliance systems around the world. Different legal systems around the world have come to embrace compliance in different ways. Some systems treat it as an affirmative defense or a way to mitigate a criminal sentence. So for example, under the United States sentencing guidelines, if a corporation has an effective corporate compliance system in place, when that corporation faces a criminal sentence, say for misconduct by one of its employees, that sentence may be reduced in recognition of that effective corporate compliance system. Under the UK Bribery Act, a compliance system is the only available affirmative defense for a corporation whose agent commits a bribe. So compliance may be an affirmative defense or maybe mitigate a criminal sentence. A completely different way to get to compliance is under a general statutory or regulatory or contractual obligation to set up a compliance system. So for example, in France, under the Sapin 2 law, there's a generalized requirement for larger companies, larger corporations, to set up compliance systems. The Federal Acquisition Regulation in the United States, under the clause at 52.203-13, it establishes a generalized requirement for larger contractors, similar to the Sapin 2 law in France, a similar general requirement to set up a compliance system. Another possible way to get to compliance is through self-cleaning. These are remedial measures after a bad act. So some systems require contractors or vendors to set up compliance systems, to set up compliance measures, remedial measures, if they're to be allowed back into public markets after they've committed some sort of bad act or their employees have committed some sort of misconduct, such as a bribe. And that self-cleaning is another way to come to compliance. All of these different approaches, however, end up in basically the same place. And as we'll be discussing over the rest of the unit, the elements of compliance systems, whether or not they're set up as part of an affirmative defense or part of a general contractual requirement or statutory requirement or part of a self-cleaning effort by a contractor whose employees have engaged in misconduct. However we get to the point of compliance, the compliance systems themselves all look fundamentally the same, as we'll be seeing over the subsequent slides. Compliance systems the world over have the same basic elements. They have a code of conduct, or standards and procedures. There's a requirement that the leadership be knowledgeable, that, for example, the board of directors be apprised, that risky personnel be excluded from the corporation or from the organization, that there be training, that there be a system for monitoring, evaluating the compliance system, that there be a reporting hotline, that there be incentives and discipline, that the program be adjusted to risk. And increasingly we're seeing in some systems, we're seeing also a call for victim compensation. For example, under the European Procurement Directive, that's Article 57 of Directive 2014-24 EU, if a vendor wants to re-enter public markets, the vendor has to ensure that the victims of its prior corruption have been compensated. So these are the basic elements that we see over and over and over again. We're going to go through each of these elements in turn after we first take a look at how different systems have applied these elements in a common way. Here you can see 5 different examples of how different legal regimes have applied the same basic standards. The U.S. sentencing guidelines, these guidelines were published for organizations in the 1990s, and they set forth the 7 basic elements we've been talking about, not including victim compensation. Victim compensation is something that's really emerging most forcefully in the European Union and now in the United Kingdom. But the 7 basic elements that we talked about before, which you see here in the left-hand column, those were set forth by the Sentencing Commission in the 1990s. The U.S. government contractors had been using compliance systems since the 1960s. It wasn't until the 1990s, however, that the Sentencing Commission codified them for corporations in general, and it wasn't until 2008 that those were applied more broadly to contractors under the Federal Acquisition Regulation. That's the second column there. The elements are all commonly adopted. The gap for knowledgeable leadership under the Federal Acquisition Regulation, the second column there, symbolized by the U.S. flag, that gap for knowledgeable leadership arises because in transposing the requirements for compliance systems, the regulators neglected to specifically require that the corporation's leadership be knowledgeable. But there's really, as we'll see in the next few minutes, it's not really possible to run a compliance system without keeping their leadership apprised of misconduct. The British, under the UK Bribery Act, the OECD, and the ICC, and literally dozens of other jurisdictions, bodies, entities, have called for compliance systems with the same basic structure. Here we see a more granular comparison between the Sentencing Commission guidelines, the contractor compliance requirements under the Federal Acquisition Regulation, and the guidance that was issued by the UK Ministry of Justice under the UK Bribery Act of 2010. And what you see as you go into deeper level here, into a more granular assessment of these different compliance requirements, again, fundamentally, they're all the same. That uniformity between compliance requirements carries between languages as well. So in France, under the Sapin 2 law, if under Article 17 of the Sapin 2 law, again, we see the same basic elements of a compliance system. These are the compliance requirements for large corporations under the Sapin 2 law, and they largely track directly to what we see, for example, under the U.S. sentencing guidelines. So let's work through the elements of a compliance system, and let's talk about what each of those elements might be. The first is to have a code of conduct, and the code of conduct will typically include a message from a senior officer calling for ethical conduct. The reason for that is pretty simple, because the rules that are set forth in the code of conduct are going to be pretty specific, but they will leave gaps, and inevitably there are situations that will arise during the course of work of the organization, during the course of work in the corporation, where there's a gap in the rules, and there's uncertainty about where to go. That's one of the important reasons for an effective tone from the top, and an effective statement from the senior leadership, for example, the CEO of the corporation, saying that the corporation is committed to ethical conduct. And that's why typically a code of conduct will include a message, again, from the senior executive calling for ethical conduct. The code of conduct will typically include an outline of a system explaining how each of the elements are going to be going through work for that corporation, for that organization. And typically the code of conduct will be based on a market standard. It might be modeled on, for example, other codes of conduct used by other corporations or other organizations in the same marketplace. The reason for this is very straightforward. It's because different organizations in the same marketplace, different corporations in the same marketplace, face common pressures, common, for example, corruption pressures. So it makes sense that they'll be employing codes of conduct that are largely parallel with one another. There's a working expectation that a part of an effective compliance system is a transparent compliance system. So there's a working expectation that the company will publish its code of conduct, which makes it even easier for others in the industry to compare notes between the different codes of conduct used by different companies or different organizations in the same marketplace. The next element of an effective compliance system is a knowledgeable leadership. Think of the leadership as the brain in a corporate body. The idea is that the brain, the board of directors, is apprised or is given notice when something goes wrong in the body of the corporation. When, for example, a line salesman gives a bribe, that the word on that will be passed up to the board. As part of that chain of reporting, the compliance officer will play a very important role. Increasingly, you'll see in guidance published by various enforcement agencies around the world, such as the Department of Justice, increasingly you'll see a presumption, an assumption that, especially in larger corporations, an independent compliance officer will be named who is independent, who stands independent of the normal chain of command. For example, independent of the chief executive officer or the general counsel. There may be a dotted line relationship. For example, the compliance officer may have a working relationship with the chief executive officer, but may ultimately be responsible to report to the board. The next element is one of excluding risky personnel. And this is can really vary from organization to organization. Under the Federal Acquisition Regulation, for example, the Contractor Code of Conduct that's called for by FAR Part 3 and the clause I mentioned before, 52.203-13, what it contemplates is that personnel who have violated the Code of Conduct, for example, if the Code of Conduct says don't bribe public employees. A person who's bribed public employees in the past would be excluded from the company, wouldn't be allowed to join the company. To make sense of this element of this requirement, it's important for companies to have vetting systems in place. For example, a questionnaire in place that will ask prospective employees what their activity has been in the past. For example, if they've been convicted of a crime. It's also not uncommon for a corporation to check the background on prospective employees to make sure that personnel who pose risk to the integrity of the compliance system will be excluded by the company. Training, effective training, is also a critical part of a compliance system. And what you see here is an example of training being done online, which is oftentimes the system used by companies because it makes it easier to distribute the training. It allows employees to take the training on an as available basis, so take it asynchronously. It also makes it easier for the corporation to track who's taken the training. Another approach is to hold live training so that the trainer and the employees get to talk in a very frank way about things that may have gone wrong in the company. Both approaches have pluses and minuses. One important thing in the training is that the company will be expected to have kept track of who actually received the training. If there's something goes wrong, if a bribe, for example, is given or an improper payment is made, one of the first questions that enforcement officials will ask was, well, who received the training and what did that training consist of? That's important for enforcement officials because if they're going to prove that an individual who was involved in improper payment had the necessary criminal intent, they'll want to be able to show that that individual has been trained in what the law is, what the law requires. So the training itself becomes part of the enforcement mechanism, and it is an important part of an effective compliance system. Again, both the training and the record keeping regarding that training. Another important aspect of a good compliance system is both a way to monitor the system, make sure that the system is working effectively, and also an audit. Sometimes, for example, the accounting firm that is auditing the company on a regular basis, the accounting firm will also provide services where it will audit the effectiveness of the compliance system. The monitoring can be done through things like logs that are kept track. They keep track of all the compliance notices that have come through. So, for example, if there are a series of notices or a series of warnings from whistleblowers that have come through, those will be logged, and then those will be monitored to see whether or not there's a pattern in those incidents, and whether or not to ascertain whether or not the compliance system has to be modified to address new emerging risks that show up in this log or this record of incidences that are coming up through the system. A critical part of this information system, the gathering of information on misconduct and then bringing that information up through the system up to the leadership, so the leadership is fully apprised. Critical part of that, a starting point oftentimes is a whistleblower, is an employee who's typically motivated by moral concerns. He or she has seen something wrong in the corporation, wants to come forward and make sure that the right thing is done. Well, that whistleblower is a very precious and important part of the overall system, and it's important that the organization, that the corporation, protect and encourage the whistleblower. It should be clear in the code of conduct that there'll be no retaliation taken against whistleblowers, and that promise really has to be kept. That's a very important guarantee that, in fact, whistleblowers will be protected. If possible, their anonymity should be protected, although that itself can be an open question in some systems and some legal regimes, some countries where anonymity whistleblowing is not encouraged. There can also be a reward, and this plays out under the fraud statute in the United States. In the Federal False Claims Act, in fact, the whistleblower is called a relator, someone who can actually, having identified a fraud in a contractor, can bring a lawsuit on the name of the government. That whistleblower recovers a share of whatever the government recovers. So not only is the whistleblower protected, not only is the whistleblower protected by, for example, rules against firing that whistleblower is actually compensated for serving as a whistleblower on behalf of the government. Built into the compliance system, there should also be incentives and discipline. So, for example, obviously if a salesperson gives a bribe to a public official, that salesperson should be terminated. This is actually more complicated than it sounds, because it may be in some companies a decision is made that middle managers who are overseeing people who do something wrong, the middle managers themselves, even if they don't specifically know of the conduct, that they'll be punished as well, this is a very difficult policy question for the corporation to sort out. And as in all of these other organizational questions that have to do with how employees will be treated, this is really ultimately a decision that has to be made in conjunction with the human resources function in the organization. In some companies, if a low-level employee commits a wrong, for example, gives a bribe, the middle manager who oversees that employee, even if the middle manager didn't know about what the low-level employee was doing, the middle manager may be held accountable, may be terminated. The working assumption is that the middle manager is personally responsible, personally accountable for ensuring that the low-level employee, when the low-level employee joins the company, knows what the rules are, and then the middle manager is accountable for supervising that lower-level employee. This explains why the middle manager will be punished even if he or she doesn't know about the lower-level employee's bribe. In essence, the middle manager is failing for not having effectively run the compliance system at his or her level of responsibility. Another important element is that the program be adjusted to risk, that the corporation be able to adjust its compliance program as it enters new markets. So, for example, if a corporation is entering a new market that is much more prone to corruption, then the corporation would want to spend more on an effective compliance system. Conversely, if a corporation is shifting from a corrupt market to a relatively clean market, then it will reduce the amount it's spending on compliance. The amount that's being spent, the effort that's being expended on the compliance system should adjust to specific risks and then to a more nuanced risk. For example, is the contractor going into a realm of sealed bidding as opposed to competitive negotiations, in which case there's going to be less compliance risk. So there are literally hundreds of factors that have to be taken into account as the contractor adjusts the compliance program to the risk that's presented. And a lot of this is a matter of doing research, for example, on what is the incidence of corruption in a new marketplace. What kinds of corruption is typical to arise? What kinds of corruption have tainted other competitors in that marketplace? These types of very, very careful considerations all go into the process of adjusting the compliance program to the new risk that's presented, which is an important part of an effective system. So this leads into how a company will build an effective compliance system. The company will first identify the risks of the company and then prepare policies that respond to those identified risks. So, and a substantial and important part of building a compliance system is setting up a series of policies that, again, respond to specific issues or risks that might arise. And then those policies are to be implemented with a specific compliance program tailored to the company's risk areas. So, for example, if a company regularly uses intermediaries such as consultants in a marketplace, those consultants also should be brought into the compliance system. They should be required to sign the code of conduct and should, if possible, take rudimentary training to make sure that they understand what the requirements are of the compliance system. For example, if the company is instead using resellers to sell its products, if the resellers may engage in corruption that could taint the company, then the company should ensure that its resellers are also bound by a code of conduct, have agreed to comply with the provisions of the code of conduct. Again, adjusting the program to match the particular market circumstances and the corruption risks that present in that marketplace. I'm going to close out here with a discussion of victim compensation. In the U.S. system, the compliance requirements under, for example, the Federal Acquisition Regulation, there isn't any clear and strong recommendation or requirement for victim compensation. That's not the case in Europe. In the European Procurement Directive 2014-24 EU, Article 57, and then under the United Kingdom's procurement regulations, under Regulation 57 there's a very clear statement that if a contractor has engaged in corruption, it can be excluded, and in order to re-enter the market, it has to fully compensate the victims. Here, for example, the victims here were victims on a train line over the Tay Bridge that collapsed because of poor design, because of inadequate design. And there's a question: was this fraud? Is this inadequate design? The bottom line is that this is an explanation of why for so long compliance systems have not embraced the idea of victim compensation. Oftentimes it's difficult to discern in the first instance whether or not there's been actually fraud or this is just negligence. Is it more serious or less serious? How in fact did the bridge collapse? Who were the victims of the bridge collapse? Are they the people who were on the train that fell into the river? Or the people who are stalled because they can't cross the bridge? Is it the owner of the bridge? These are very complex questions. They lead into further questions. How, for example, if we could identify who the victims were on the train that crashed into the river here, how do we identify who their next of kin are? How do we make sure that they're compensated? It's a very, very complex question, victim compensation. It sounds simple, but it's very complex, which again is one of the reasons why it hasn't traditionally been part of the normal sentencing guidelines in the United States. But again, it is part of the European system for those corporations that, again, have been tagged with some sort of misconduct if they want to re-enter the public markets. So having identified victim compensation as a requirement, one has to ask how this actually affects the strategy of the company setting up their corporate compliance systems. Because of the complexity of ensuring that victim compensation is made correctly, it's likely to be a sticking point between the company and the enforcement officials, let's say the contracting agency that is requiring victim compensation before it's going to allow the company back into the public markets. And because of the complexity of that, and because of the fact that the parties may well reach impasse, in some ways, a savvy company will develop strategies for victim compensation, will come to the table with recommendations, with suggestions on how it can affect victim compensation, so it can help move the dialogue forward with enforcement officials or with the contracting agencies. The fact that victim compensation is becoming an increasingly important part of the compliance landscape creates an incentive for companies to think this problem through ahead of time. Once there is a catastrophe, once there are victims, to sort out what's the right way, what's the best way from a reputational standpoint, from a remedial standpoint. What's the best way to address victim compensation as part of an overall strategy for corporate compliance? Thank you very much for joining this unit on corporate compliance.